So, no, I wouldn't say I have a passion for HR.
Welcome back to Human Resources for the People. It's a human capital
Today, we're going to be talking
revolution.
about the National Labor Relations Board finding that Home Depot violated the National Labor Relations Act by terminating Antonio Morales for wearing Black Lives Matter insignias on his company uniform. So let's get into it. Let's start talking about it. Now, this ruling came down on February 28th, and they ruled that, again, that Home Depot violated Section 7 of the National Labor Relations Act. Now, let's give a quick overview of Section 7. Section 7 of the NLRA is a crucial provision that safeguards the rights of employees to engage in concerted activities for the purposes of collective bargaining and mutual aid or protection. Enacted in 1935, Section 7 grants workers the fundamental freedom to form, join, or assist labor organizations as well to engage in collective bargaining with their employers. This section ensures that employees have the ability to collectively advocate for better wages, working conditions, and benefits without fear of retaliation or discrimination from management. By protecting the rights of workers to organize and bargain collectively, Section 7 plays a pivotal role in balancing the power dynamics between employers and employees. So in 2020, Antonio Morales wrote BLM on the work issued apron to bring attention to racism in the Minneapolis store. One of the reasons he was bringing attention to racism in the store is that one of the managers said that he should watch out for a black customer because, quote, people of Somali descent were more inclined than others to steal, which got Mr. Morales very upset. This reversed a lower labor judge in 2022, and in 2022, the BLM manager messaging was not protected because it didn't address working conditions in the store, and they weren't organized in a group setting. The administrative law judge ruled that it, quote, lacked an objective and sufficiently direct relationship to terms and conditions of employment, and as a result wasn't protected. But ultimately, in this case on Wednesday, the National Labor Relations Board found that other employees actually engaged in this, that there were discussions of this at the workplace. They complained of racial discrimination by a coworker, and there were two incidences of vandalism of a Black History Month display. And so as a result, these complaints, this concerted effort, concerted activity together with these employees were for the purposes of mutual aid or protection. And then with Morales and two other employees began wearing the BLM markings around the same time. And it was as a result of a, quote, logical outgrowth of prior concerted activities. And so it was becoming clear that these employees, while not attempting to unionize or anything, were attempting to concertatively work together to, push this problem that they saw in their store. The dissenting opinion in this case, which noted that it opens up a, quote, Wild West frontier of concerted activity by individual employees, contrary to the obvious intent of the National Labor Relations Board and the National Labor Relations Act, right? And this does also conflict with a Fifth Circuit Court opinion that the National Labor Relations Board overstepped its authority when saying that Tesla committed an unfair labor practice charge by enforcing a dress code. Because, ultimately this is what happened. Home Depot was enforcing a dress code policy, and as a result, was asking Mr. Morales to not wear this insignia on his company uniform. Sometimes I fail to highlight the result of these cases, and I want to make sure that I highlight it here. So under the remedy section of this, you can take a look at what they have to do. And so as a result, they found that the respondent, Home Depot, violated Section 8A1, and as a result, Home Depot has to provide full reinstatement to their former job. In addition, Morales gets paid any loss of earnings and other benefits suffered as a result of their unlawful constructive discharge. And so they have to compound the interest daily, which could be significantly expensive for Home Depot. In addition, Home Depot has to pay for any future harms that could be as a result of the constructive discharge, including reasonable search for work, employment expenses, et cetera, et cetera. So it can be quite far reaching. And finally, the court said that, Home Depot must cease and desist from applying its dress code and apron policy to Section 7 protected employee activity. And so that is the result of this particular situation, which again, I don't typically cover. And so, what do you think? Is this substantively broad? Is this a very broad prescription of what constitutes concerted activity? Ultimately, the problem here is that these things move back and forth very frequently. With a new president may come new decisions on the part of the National Labor Relations Board, and that poses a lot of problems for employers to understand how the tea leaves are changing and what might come from that. Let me know in the comments down below. Like, share, and subscribe, and I'll see you on the next video. Bye, guys.